We now move on to our next presenter, Kshetragna Pinnamaraju. He's a fourth year Nalsar student, and his paper is titled The Empire Strikes Back, The Empire Strikes Back, Eroding Community Forest Rights and Tribal Dignity. Very powerfully and evocatively phrased paper.
Good afternoon, everyone. First of all, I would like to thank Professor Vasanthi, Professor Murli, and the entire team of the IGCL and organizing committee for giving me this wonderful opportunity. It's truly a privilege to be able to present with this esteemed panel today. I'm Kshetragna Pinnamaraju. I'm a fourth year law student at Nalsar University of Law. Today, I'll be presenting a paper called The Empire Strikes Back, Eroding Community Forest Rights and Tribal Dignity. This paper interrogates the Indian forest regime, and I make a simple argument. It is a simple but a pertinent one, that the state has together constructed a legal architecture that renders the tribal dignity, both tribal dignity and the forest rights, illusory and nugatory. To examine this, to examine this erosion, I shall use the ideas of Giorgio Agamben's idea of bare life and homo sacer, to show how forest-dwelling communities are reduced to politically invisible beings, governed, displaced, and easily dispossessable. I argue that this is not a product of oversight, but a product of design. Before we move on, before I dive right into my argument, I wanted to establish the history of forest legislations in India and governance per se. The forest governance in India began through in the pre-colonial era. The order of was decentralized, community-driven, and embedded in local customary systems. Forests were governed through knowledge, systemic obligation, and relations within each other. This logic was completely inverted when the colonial regime took over. Forests became economic commodity of the state. The Indian Forests Act of 1865 and 1927 institutionalized this extractive sovereignty of the state. It criminalized access and introduced a central exclusionary forest bureaucracy. Post-colonial governance did not rupture this model. It actually refined it. The Forest Conservation Act of 1980 was born out of environmental concerns largely. But what it did was it still retained the colonial template. It introduced, the forest still remained state-owned, and the people that lived in the forest through generations were kept out of the system. But this historical arc that I'm displaying right now, while important, is only the prelude to what should have been the discourse and shift in the discourse, a legal alignment that never fully came. Now, moving on, my primary focus of this paper is going to be on the scheduled tribes and other traditional forest dwellers recognition of Forest Rights Act. This act, if we observe the preamble of this very act, it becomes very clear that the object of this act was to correct a historical injustice that was done to the forest dwelling communities and also the tribal people that have been living in this forest through generations. And for the first time, forest dwelling communities were recognized not as encroachers, but as rightful custodians of forest land. The FRA granted a spectrum of rights to these individuals, such as habitation rights, and most importantly, the right to protect, regenerate, and manage forests under Section 5. But this wasn't just merely a symbolic gesture on paper. The law embedded this authority in a participatory multi-layered claims process. The procedure begins at the level of the Gram Sabhas. The Gram Sabhas typically involved the village elders, which again, where claims are filed and reviewed by forest rights committees. These committees must be composed from members of the community with adequate tribal and gender representation. The FRCs could conduct field verifications and submit their findings to the Gram Sabha, which then passes the resolutions. All the people, all the members from the forest dwelling communities and the tribal communities were required to file claims under this procedure under the FRA to be recognized as the rightful custodians of the land that they've been inhabiting since centuries. From there, the claims move to the subdivisional level and the district level committee, which is headed by the collector. In design, this was not just an administrative process, right? It was a constitutional mechanism of decentralizing power and restoring self-governance back to to the people whom it actually belonged to. But this promise comes with a built-in contradiction. If we look at Section 13 of the Forest Rights Act, if I may read it out, the provisions of this act shall be in addition to and not in derogation of the provisions of any other law. I want that thought to sit with all of you for a moment. On surface level, it appears very harmless, right? It appears benign, like it almost appears cooperative. But in effect, it functions as a Trojan horse within the system and scheme of the act. What it does is, as I pointed out, the preamble of the act recognizes and understands that the Forest Rights Act was enacted to correct a historical injustice that was done to these communities. What this particular provision does is it ensures that these systemic frameworks that created and reinforced and continued this systemic exploitation and historical injustice continue to survive alongside the Forest Rights Act. On the surface, rather than repealing or overriding the colonial legal framework that criminalized tribal presence in forest, Section 13 allows it to survive alongside. Laws like the Indian Forest Act, the Forest Conservation Act, and the Compensatory Afforestation Fund regularly have provisions and are constantly reviewed and amended that have provisions that not only contradict the particular provisions of the Forest Rights Act, but also the direct object of the Forest Rights Act. And Section 13 also enables the state to introduce new rules, such as the forest conservation rules, alongside that are outside the sphere of the Forest Rights Act, but still relegate this Forest Rights Act to subvert the object of it. This is not legal harmonization. For a state that is known for excessive use of its non-obstante clauses everywhere, non-obstante clauses are typically used for clarity, but the state has exceeded its use so much that it causes more confusion now than clarity right now. But if you see the importance of the act like this, and you see the provision that is Section 13, it very much embodies a Trojan horse within the scheme of the provisions. I attempt to demonstrate why this provision is typically breaking the spine of the Forest Rights Act and its emancipatory promise. The Forest Rights Act contains within it a provision that says that the prior and free informed consent must be obtained of the tribal communities and the Gram Sabha before any forest land was to be divested. What the forest conservation rules of 2022 do is that under the Forest Conservation Act, the Union government still holds the authority to divest forest lands. What the forest conservation rules do is they delegate this responsibility to the state government once the approval is obtained from the Union government. Once the funds have been collected, once the compensatory afforestation payment and the net present value payment is done, they delegate this responsibility to the state government, which are now obtaining consent ex post facto, which directly runs contrary to the progressive judgments that came out in cases of Orissa Mining Corporation, which is popularly known as the Vedanta judgment. And secondly, the Forest Conservation Amendment that came in 2023, which constitutionality is now under challenge, the 2023 amendment goes further. It allows the land to be diverted freely if the forest land is not part of the government records. This is again directly running contrary to the progressive judgment that laid down that even the definition of forest should be the layman term as laid down in the T. N. Godavarman case. What this effectively does is this creates a dangerous friction. The forests without paperwork do not legally exist. It ignores the lived reality of the Adivasi communities who have conserved and depended on this forest for generations, regardless of colonial record keeping. In one clause, forests become invisible. So do the people who protect them. But why does the system function this way? What sustains this architecture? In practice, if any of us open our browsers in our devices at this point and just Google or like search Forest Right Act claims rejected, we will find about thousands of articles of different states, different territories, different districts where en masse these applications are rejected for insufficient evidence and the hierarchical approach of Gram Sabhas. In the state of Chhattisgarh, the Forest Department actively passed an order that precluded any NGOs from supporting the Gram Sabhas in making these adjudicatory claims. What this effectively does is that you are asking to justify their presence in a place where they have considered home from several centuries, but also asking them to provide documentation which they were never allowed to have in the first place. Moving on, I want to present 3 case studies And before we move into this, I want to understand this from the perspective of the state as well. The state earns from forest diversion through compensatory afforestation fund act, net present value payments, and mining licenses. In contrast, recognizing tribal rights is often met with delays, bureaucratic hostility from the forest department, and it invites resistance from groups because the Forest Rights Act has been challenged, its constitutionality has been challenged by ecological conservation groups right now. This is why rights claims are rejected without review, why Gram Sabhas are ignored. It is not efficiency, it is incentive. The system does not go beyond its scope, it works exactly as intended. And when this incentive structure collides with the powerlessness on the ground, it produces patterns once we can observe through these live case studies. These 3 case studies that I've gathered here, in the state of Odisha alone, they were about 140,000 applications that were 140,000 applications that were rejected of this. In the year 2019, the Supreme Court passed an eviction order against 16 lakh people who live in this forest. So what we understand from this is that the Forest Rights Act was enacted for the purpose of granting the community and forest dwelling communities the community rights that they've always had. What is being done is that once their claims have been rejected, this rejected claims are being used to evict them from the forest that they have inhabited since years. This effectively, to me, turns the object of the Forest Rights Act on its head. And lastly, there are many ecological concerns that come that point out that how can they are coming from very paternalistic spot that point out how can a forest dwelling community or how are people who are living in the forest from several years can contribute to its effectiveness. For this, I want to point out the third case study that I've gathered here. The third case study is particularly in the village of Odisha, where the governance and the forest right claims were accepted by the community, by the Gram Sabha, and it led to a revival of the forest and revival of an endangered crops and other things. And this is how I would like to counter the dominant narrative of ecological concern versus tribal custodianship of the lands that they've always belonged to. Moving on, I want to understand this governance.
Last 2 minutes.
Yeah, and I'll conclude, Professor. That this governance model does conceptually. I turn to Giorgio Agamben's concept of bare life and the figure of Homo sacer. So Agamben divides life into 2 components. He has bios and zoe. So what he says is that, as Professor Daly pointed out during her presentation, the Supreme Court likes to keep saying that Article 21, the right to life, means more than mere animal existence. The zoe is the biological fact of merely being alive, and the bios is the political life. It is not just the manner or existence of life, but how you live it, your involvement in social and political life. This too, Agamben argues that when you are stripped of your bios and only zoe is remaining, you are what is known as bare life. To demonstrate this concept, his primary example is that of a Homo sacer. I'll take 1 minute to briefly run you through the concept. Homo sacer is an ancient figure in Rome, a historical figure in ancient Rome. He was sent out when the war was already lost, when the battle was already lost. His only role was venturing out and killing as many people as possible as a tribute to the gods. In the rare scenario that he was effectively sacrificed by the state to perform his duty, to perform this tradition. In the rare scenario that he was found alive and he returned back to Rome, he was stripped of bios and any social and political involvement. What remained purely was bios. What remained purely was his zoe. This, Agamben points out, is stripped to bare life. He had no legal standing, no right to be mourned. He existed in a place where the law saw him but no longer protected him. This framework is what I argue should be placed on the forest dwelling communities and the tribal people who are being forced out of their forest, forced out of the place that they've protected since centuries. This is what India's forest governance does to tribal communities. They are acknowledged in census records, statutes, schemes, promised recognition under the FRA, referred to in government guidelines, but when it comes to power, to self-governance, to protecting their forests, they're already sacrificed. Their consent is bypassed. Their claims are rejected. Their resistance is criminalized. They are alive, but in the eyes of law, they have already been abandoned. Like the Homo sacer, they are present, but outside the protection of the legal and political order. Governed, but not represented. Counted, but not heard. And this is not neglect, it is systemic structure, a structure that legally produces bare life while invoking the rhetoric of inclusion and dignity. Now, lastly, just concluding remarks, Professor.
30 seconds.
Yeah. What the state calls dignity in forest governance is not empowerment. It is administrative mercy. If we understand the 2019 judgment or the order that was stayed right now about the eviction of about 16 lakh people, it does not treat the Gram Sabha adjudications as a possible administrative discrepancy. It treats it as a final verdict, and it is forcing them to move it out. A recognition that arrives only after displacement, a consent asked only after clearance, a right framed as a privilege, and that is the logic of bare life. To appear inside law, but only through exclusion, to be seen, but never allowed to speak back. Dignity is not something we stitch together from state approvals, procedural scraps, or delayed recognitions. It is grounded in self-determination, autonomy, and custodianship of the land that they have continued to protect since centuries. That is where my presentation ends, and where I hope the imagination begins. Thank you.
Thank you. Questions? Yes.
Hello. Brilliant presentation, Kshetragna. Really insightful, really passionate. I just wanted your, and I agree with you on all the points you mentioned. I just wanted your response on one thing. So, what Section 13 of the Act does is, it does not say that other acts are somehow superior to the other. It just sort of like clarifies, and to quote, it just mentions that this is in addition to other acts. Okay, so it does not create a hierarchy. And at the same time, what the Supreme Court's judgment in Vishal and Kalsaria versus Bank of India does is that it holds that when a factual matrix is governed by two laws, and in those two laws, one of them is a social welfare legislation. In such an incident, the social welfare legislation's interpretation and application should be upheld over the other law. The act, the case dealt with Rent Regulation Act and Sarfesi. Now, in lieu of this, how do you respond to this, like the apprehension that you raised, and the answer that how do you respond to that?
Thank you so much for that question.
If there aren't, then I thought I'll just ask you something. You were there yesterday.
Yes, ma'am.
So I was wondering, how would you respond to what Professor Barua was saying, that this idea of community rights has no philosophical foundations? I thought maybe you will start with that and then also take.
Audio is working. No, I got the question. Thank you so much for both the questions. With respect to the community forest rights and how it recognizes it, the Forest Rights Act clearly delineates between the individual rights that a member from the tribal community or a forest dwelling community has, and vis-a-vis what a community right is. A community right is garnered in the fashion that the right to harbor produce and sell it, and like use the produce in a equitable way. And when it comes to forest particularly, and the communities that are living in the forest from generations, it becomes very difficult to separate the individual from the community. What I remember is in one of the judgments, I don't recall the exact judgment, but and it pertains to one of the questions that Saksham asked previously too. When you're talking about liberty in the framework of the Constitution, it not just means liberty in the community, but liberty from the community as well. But in my opinion, the Forest Rights Act embodies both individual rights and community rights, which allow you and enable you to do so. And if in practice it is operative, but right now I don't think it is. And answering to your question, Saksham, as if you refer to Section 13 directly, it says not in derogation and in consonance with other rights. But as I pointed out, the framework of Forest Rights Act is never diluted directly. What the state is effectively doing to subvert the law is it is passing amendments and new rules under the Forest Conservation Act, the Compensatory Afforestation Act, and other things. So what it effectively does is that none of the provisions are directly in derogation of the Forest Rights Act and any of its social justice provisions. What it inevitably does is that when you have a particular provision that says that you have to mandatorily obtain free and prior consent of the communities and Gram Sabha, and then you're passing another rule under another act which falls outside the sphere of this act and saying that this consent can be obtained ex post facto, you're diluting it indirectly. And there are doctrines that say that what you can't do directly and what you can't do directly, you can't do indirectly. But sadly, very rarely you use that doctrine to, very rarely you use that doctrine in cases such as social justice to justify this theory of, or hold the state justifiable. And that is it. And when it comes to the social justice provision versus this case that you pointed out, it becomes very tricky in this particular thing because this section 13 does not operate as a non-obstante clause. And when you're talking about Forest Conservation Act, how would you exactly interpret, or how exactly would you identify the nature of the Forest Conservation Act or other things? Because end of the day, the Forest Conservation Act, the Wildlife Protection Act could also be social justice provisions because they are protecting it. Thank you so much.
Thank you, Kshetragna, for allowing us to think from the perspective of, or bring in the work of Agamben to think about how state can operate outside of legal norms and what it does to people who are living on the margins with